Good afternoon. I'm Bradley Graham, the co-owner of Politics and Prose, along with my wife, Lissa Muscatine. And on behalf of the entire staff, thank you so much for coming out on such a dreary, wet Saturday afternoon. Chris Edelson is an assistant professor of government at American University's School of Public Affairs. He teaches a course there to undergraduates in constitutional law. He's practiced law in D.C. Before becoming a teacher, and has served as a state legislative director for the Human Rights Campaign here in D.C. In his new book, Emergency Presidential Power, Chris examines the sources and limits of presidential power. He wrote the book because, well, he needed it to teach. Several years ago, when he sought to teach a class on emergency presidential power in the war on terror, he couldn't find a suitable primer on the subject. I think that's just great. I mean, don't you love it? You know, you're a teacher, you can't find a book, so you just decide to write it. And you just have to take a look at today's headlines, or the headlines that appear regularly in the papers, to appreciate the tremendous relevance of this whole question of emergency powers, whether the issue is drone strikes or indefinite detention or warrantless eavesdropping. How a president should handle these emergencies or crisis situations can't be easily determined simply by turning to Article 2 of the Constitution. So Chris has surveyed the evolution of the exercise of executive power in this country from the administrations of George Washington and John Adams right up to the present-day Obama administration. The documents he's collected here in this book and the analysis he offers in it provide a very helpful foundation for better understanding the debate over current policies and practices. So, ladies and gentlemen, please join me in welcoming Chris Edelson.
Thank you so much. I appreciate the introduction, and I have to mention immediately, Politics and Prose. This is a place I've wanted to speak at for as long as I've thought about the book. It's an incredible place for people who've been here before. I'm sure you know that. It's a real gem. And when the book was published by the University of Wisconsin Press, when I told them I was speaking here, I figured I'll have to explain what Politics and Prose is. They immediately said Politics and Prose is legendary. It's known everywhere, and it's just such a great place. So I deeply appreciate having the opportunity to speak here. So I'll try to speak briefly, as I'm interested to hear questions. Some students are here, which is great to see. This, as was mentioned, this is a book that I created out of materials I was using for a class. The reason I wanted to teach the class was couple of reasons, really. I was living in New York on September 11th and was really scared. I mean, I thought the attack itself was scary. I figured this was going to be the start of many, many attacks. And of course, there have been, a lot of times you hear this idea, well, there were no attacks after September 11th. That's not actually true. There have been a number of attacks. There were the anthrax attacks right after September 11th, still not really explained. A number of people were killed. July 4th, 2002, there was a terrorist attack at an LL ticket counter in Los Angeles. There, of course, was the shoe bomber, Richard Reed, fortunately not successful. Christmas Day bomber, 2009. The Times Square attack. There's been a number of attacks. Of course, the Fort Hood shooting. So there have been attacks. But what I was kind of bracing myself for was there will be attacks every day. This will be just kind of the new state of being. And I was scared. And I was certainly hoping there would be some kind of government response. And I became concerned when I saw what was happening, though. I started to ask questions. You know, when we ended up, the United States ends up attacking Iraq, and it turns out the information was pretty clear even before the attack was not correct. And you heard these explanations for what was being done in the context of the war on terror. We need these military trials that hadn't really been used since World War II. We need to set up Guantanamo and hold people there. Most of them actually, Guantanamo is really a detention system. Most people there have not received any trial, military, civilian, or otherwise. And a lot of the arguments I was hearing, I've always been interested in history. I'm a lawyer by background, but I like history as well. And when I teach classes on the Constitution, it's in the context of history. This class I teach, a student here took as well. It's kind of a constitutional overview of the Constitution in historical context. So I heard these arguments that this can be justified. What's being done now? Military detention, military trials, broad executive power can be justified because past presidents had done the same thing. Lincoln and Roosevelt is typically you hear invoked. And I wanted to see, is that correct, first of all? And even if it is correct, is that a good justification? Of course, just because something has been done doesn't necessarily mean it's right. I mean, Roosevelt and Lincoln might have made mistakes too, and they certainly did. So I wanted to find out more about this. I was going to teach this class, and as was mentioned, I was looking for a book. I couldn't find one, so I started creating materials. And it was another professor at American University, a couple of colleagues are here as well, which I deeply appreciate too. Another professor in the department said, hey, you've got these materials, why not turn it into a book? And I said, well, I've always wanted to write a book. That's a nice idea. So I started doing it. My wife very kindly helped make time for that and reviewed the book from the beginning. She's here as well. The book's dedicated to her, actually. And I started writing the book. And what I wanted to talk about quickly before I get to questions, which is what I'm most interested in, is a couple of interesting things and sort of disturbing things I learned as I was writing the book. I'll pick one from the Bush administration, one from the Obama administration. The book is a historical overview, and I'm glad to talk about anything. It starts with Washington, Adams, Lincoln. I talk about 19th century, Wilson, World War I. Anything's fine. But to me, I said I'm interested in history. The thing that's always interested me most about history is how it relates to what's going on today. I mean, history, of course, is interesting in and of itself, but I think it's most useful, most interesting in terms of what it can tell us about what's going on now. So let me talk about a couple of things in recent history. The Bush administration, as I said, they like to invoke Lincoln, especially Lincoln, Roosevelt as well, in defense of these broad executive actions like Guantanamo, warrantless surveillance, military detention. There was a lawyer named John Yoo. Have people heard about him? Some people from class obviously know, and other people have heard as well. John Yoo is really a notorious figure. I think he deserves more notoriety, actually. One of my plans for a future book will be to focus on John Yoo and maybe he's not the only one. Other government lawyers, I think, have done things that are concerning as well. But to kind of look at what he's done and explain what happened. John Yoo was the legal architect, one of the central legal architects for this theory called the unitary executive theory, which is basically the idea that the president can set aside the law, even criminal law, if the president concludes it infringes an executive power. John Yoo wrote a number of memos which were initially secret. That's one really big problem about this as well, I think. How can you even decide whether presidential action is constitutional if you don't even know it's happening? He wrote these secret memos, one just after September 11th that said that the president can use military force whenever he wants to for whatever reason. Congress cannot stop it. It's an incredible memo. Not incredible in a good way, incredible in kind of a startling way. He wrote another memo justifying warrantless surveillance, and he wrote a memo that I want to talk about briefly today justifying torture. What happened was, in the summer of 2002, the CIA, the government had taken into custody. The FBI interrogated him initially, a man named Abu Zubaydah. And the CIA was not satisfied with the FBI's interrogation methods. The FBI interrogated this man. He's in custody. It's the summer of 2002. And there's understandably a concern. I don't mean to diminish this, by the way. There's one of the problems in talking about the war on terror is when you look critically at presidential action, sometimes people think, oh, you're dismissing the threat of terrorism. I would say, no, of course not. There is unfortunately a real threat of terrorism. It is a real concern. The question is, does that mean that everything is justified in its name? Just like in World War II, there really was a threat that Japan would attack the United States. Japanese warships were operating off the west coast of California. The question is, did that justify the internment of Japanese Americans? And the book, I would say no. The same question now. There is a threat of terrorism. Does that justify what was done in its name? In the summer of 2002, there's this guy in custody, Abu Zubaydah. The CIA says this is the number 3 leader of al-Qaeda. He will have information about anniversary attacks that may be scheduled. They didn't know this was scheduled, but they thought al-Qaeda has a history of planning attacks on anniversaries. There may be an attack on the first anniversary of September 11th. I think that's a very reasonable concern. Obviously, I didn't have access to any intelligence, so I don't know specifics, but I don't think that's unreasonable in and of itself. What happened from then kind of went in a disturbing direction, though. So first of all, it turns out Abu Zubaydah was not the number 3 leader of al-Qaeda. He was kind of a lower level guy, kind of guy who would help someone find a safe house or get them money if they needed to, buy a plane ticket. So many of the people held at Guantanamo were absolutely innocent, and many have been released. They simply were turned over for bounties in the wrong place at the wrong time. Lots of stories like this. Abu Zubaydah is not one of them. He's not an innocent per se. He was certainly associated with al-Qaeda, but he was not a leader. And the basic premise for this interrogation was he's a man in leadership. He will know about future attacks. So the CIA starts with that premise. They want to use these, they call them enhanced interrogation methods. It's just torture. It's waterboarding, sleep deprivation. They wanted to put him, they had learned, I believe the FBI found this out, and the FBI used more traditional techniques, talking to him, gaining his confidence, the kind of stuff you'd see on television police shows. No physical, interrogation methods. They had learned that he was terrified of stinging insects. That's just his fear. I'm really afraid of sharks. He's really afraid of stinging insects. Just his fear. The CIA said, we want to put him in a coffin-like box with a stinging insect. That's, people have read 1984. Basically, that's room 101 in 1984 is where you go and your greatest fear happens. So the CIA wanted to do. So they're concerned, though. There are laws that make it a criminal offense to torture. The United States has ratified the Convention Against Torture. There's a U.S. criminal law that imposes very serious criminal penalties for torture, the anti-torture law. The Geneva Conventions prohibit torture, not just for, a lot of times you hear about this idea, terrorists are not prisoners of war. Yeah, that may well be true. They're still protected by the Geneva Convention. So Common Article 3 of the Geneva Conventions applies to everyone. And it sets basic standards of kind of decent treatment for prisoners, including prohibiting torture. So the U.S. law says that if a grave breach of the Geneva Conventions is a war crime. So they're criminal laws. The CIA says we want to use these methods, which had been used at various points in American history, actually. And there had been prosecutions for this. So were U.S. soldiers who used waterboarding on Filipino guerrillas in the Spanish-American War, they were prosecuted. The U.S. had prosecuted Japanese officers who waterboarded American prisoners during World War II. So the CIA interrogator said, we want to use these methods. They might be criminal offenses, though. So we're going to go to the Department of Justice and ask for clearance. The man who looks at it is this guy, John Yoo, this young man at the time, about 34, 35 years old. Background as an academic. That's not necessarily a bad thing, but, that's he wasn't someone. My point is he wasn't exactly immersed in the techniques that he was looking at. He didn't really know much about waterboarding or sleep deprivation or putting people in boxes with stinging insects. But he decided that all of these things would be okay. And the memo he wrote is just astounding. It's when I read one of the reactions I had, it reminded me, and my point here is not that John Yoo is a Nazi or Bush is a Nazi or Obama is a Nazi. Only the Nazis were Nazis. But when I read the memo, the phrase that came to my head was banality of evil. Hannah Arendt's phrase, which is itself sort of a controversial phrase. But what it meant to me when I thought that was there was this lawyer sitting in an office down by the National Mall where I go, right across the street from the museums. And he was sitting there, the Office of Legal Counsel, part of the Department of Justice. And he wrote this memo. He just said you probably went out to lunch, went out to get coffee, got a sandwich. And in between doing that, he wrote this memo that justified torture. And it's pretty chilling. And what he says in the memo is, first of all, he defines torture. Torture is not clearly defined under U.S. law. That's true. It's understandable that when the law was written, they didn't want to say the following things are torture because they might leave something out. So what the law says is if someone's in custody and you subject them to severe physical or mental pain, that's torture. So John Yoo says, how do we know what severe physical pain is? Well, there are different ways he could have understood that. He could have said, let's think about in the past how we define that. Waterboarding, in 1944, the Supreme Court had said sleep deprivation. In that case, it was used in the context of a domestic criminal investigation. The Supreme Court very clearly said sleep deprivation is one of the oldest forms of torture associated with the Spanish Inquisition. They said it very plainly. John Yoo did not cite that case. He's a lawyer. I'm sure he knew about it. He didn't cite that. He didn't talk about past prosecutions under U.S. law for waterboarding. Instead, what he did, and it's stunning, and he was investigated. The Office of Professional Responsibility called this gross oversight in his part. Probably an understatement. He took a healthcare benefit statute that defines when people would get benefits. If somebody is sent to the hospital in an ambulance, when do they get reimbursed for that? And in the healthcare statute, it used the word severe pain. They're in there, but it didn't actually define it. And then kind of later in the paragraph, it says if somebody experiences pain that's equivalent, or no, it doesn't say experiences pain. It says if somebody, it does. If someone experiences pain equivalent to death, organ failure, or impairment of bodily function, they can be reimbursed if they're put in the ambulance and sent to the hospital. John Yoo said, so that's what severe pain means in the context of torture. You can only torture somebody. It's only torture if you subject them to physical pain that's equivalent to death, organ failure, or loss of a bodily function. John Yoo was asked once, how do you know what pain associated with death is? And he said, I don't know. I imagine it's pretty severe. I mean, obviously, no one. It's a really vague standard. And what he did with that standard is he basically said almost nothing counts as torture. If you think about it rationally, if that's the standard, that would mean Cutting off someone's finger is probably not torture. Pulling out someone's fingernails is not torture. It's very painful, but is that equivalent to death? Probably not. Burning somebody with a lit cigarette probably is not torture, although he sort of hedged on that in the memo. So that's his first point. He says almost nothing is torture. Waterboarding won't be torture. Sleep deprivation won't be torture. Although even under his definition, I would argue waterboarding is torture. This I think is an important point to make because there's misunderstanding about waterboarding sometimes. When I started doing this book, I had heard about waterboarding, and you always hear it simulated drowning, right? That's the phrase, the media uses that all the time. It turns out that's not really correct. So the U.S. government uses waterboarding sometimes on U.S. soldiers. Does anyone know why, by the way? You think Liz Cheney, I've seen, she says it can't be torture. We use this on U.S. soldiers. That's really kind of it's a meretricious argument. Does anyone know when it's used on U.S. soldiers? Oh yeah, exactly. Exactly. There's a program called Survival, Evasion, Resistance, Escape, the SEER program. That's used for people who are in like Navy SEALs who are going to be, greater possibility of being captured, and they're trying to prepare them in case they are subject to torture. Malcolm Nance, who was a trainer in this program, talked about waterboarding. He said, waterboarding is a torture technique, period. It is not a simulation. Unless you have been strapped down to the board and have endured the agonizing feel of the water overpowering your gag reflex and then felt your throat open and allow pint after pint of water to involuntarily fill your lungs, you will not know the meaning of the word. Waterboarding is controlled drowning. The victim is drowning. There's no way to simulate that. The lungs are actually filling with water. Waterboarding is slow motion suffocation with enough time to contemplate the inevitability of blackout and expiration. Usually the person goes into hysterics on the board. For the uninitiated, it is horrifying to watch. If it goes wrong, it can lead straight to terminal hypoxia. It means you die. When done right, it is controlled death. Its lack of physical scarring allows the victim to recover and be threatened with its use again and again, which obviously Zubaydah was. Apparently, he was waterboarded 82 times. There were videotapes of this. They were destroyed. Another man, Khalid Sheikh Mohammed, again, no saint. Khalid Sheikh Mohammed is the self-described mastermind of the September 11th attacks, was waterboarded apparently 183 times. So John Yu's first conclusion was none of these methods are torture. His backup argument, though, is what really got me. His backup argument was this unitary executive theory I mentioned. And what he said was, even if I'm wrong, and even if any of these methods are torture, the president can still order them because Congress cannot limit the president's power. This criminal law that Congress has passed, the president can secretly decide to set aside. You can't be prosecuted for this. One government lawyer described this as a get out of jail free card. Most of these methods were used. The CIA did not ultimately use the insect in the box method. They were cleared to do it if the insect did not really sting. They were allowed to do it if they told Abu Zubaydah it would sting. They didn't use that. They did waterboard him. They did use sleep deprivation. The implications of Yu's memo, I think, are especially remarkable. So Yu's conclusion is basically if the president wants to order any method, he can do so, whether it's been prohibited or not. That's the logic of the unitary executive theory. And in case maybe someone's misunderstanding, John Yoo was asked about this. He had a debate with somebody, and the man he was debating with said, wait a second, what if the president wanted to, let's say the president has someone in custody who is a terrorist or they think is a terrorist, whichever it is, and they have the person's child as well. What if the president wanted to order that, wait, make sure no children are here. Oh, good, it's a little graphic. What if the president wanted to order an interrogator to crush the testicles of the child? John Yoo said, it would depend on why the president thinks he needs to do that. That means it could be okay. And the audience sort of nervously laughed at that. That's pretty remarkable. So that's a torture memo. That's the Bush administration. There are a number of other examples that I talk about in the book. There's a really remarkable scene involving John Ashcroft in a hospital bed where Ashcroft is a figure I didn't think so sympathetically of initially, but he actually did the right thing at an important juncture when it came to the warrantless surveillance program. There's a bizarre scene where he's in the hospital bed. The White House wants to get this warrantless surveillance program cleared. Ashcroft is incapacitated. His number two is in charge, and the Bush administration tries to go around the number two and basically get Ashcroft to sign something when he doesn't know what it is. It's like a scene out of The Godfather. Have you ever seen The Godfather where Marlon Brando, the Don, is in the hospital and Al Pacino rushes over there to get there before the other mobsters? That's what happened in this case. The kind of good guys in the Justice Department knew that Andrew Card and Alberto Gonzalez were going to the hospital to maybe hold up Ashcroft's hand to sign a authorization, and they got there first and told Ashcroft what was happening. And Ashcroft, to his credit, I think, said, "I'm not doing this in any event. I'm not the person in charge right now." So I talk about that in the book as well. I'll stop there on the Bush administration. When Obama took office, I think a lot of people thought, and certainly I did too, this will be a really significant juncture. This will turn out to be a blip. We had these years where one commentator said, we didn't know it, but from 2001 to after September 11th attacks until Bush left office, we lived under a dictatorship. I mean, that's not true in all aspects of life, but the unitary executive theory, the idea that the president is above the law, there's some truth to that. So Obama runs for office and he says, Bush administration violated the rule of law. I'm a constitutional lawyer. This is wrong. We're going to set things right. He had lawyers, other prominent lawyers, a man named Harold Coe, who was the dean of Yale Law School, saying the same thing. It sounded great for people who cared about the rule of law, and I thought, that's good. Obama comes in office. In many ways, and my next book is going to be about the Obama administration, how I think in many ways, it's not so simple, but in many ways they've taken a similar approach to the Bush administration. There are differences, of course, but important similarities. Obama comes into office, and he does in some ways, I think really, this is really a problematic thing, fails to reverse course and fails to dramatically repudiate what's happened under the Bush administration. It's happened in several ways. There could have been prosecutions. The United States, when you sign the Convention Against Torture, you have a responsibility to prosecute torture. So he didn't do that. That's one problem. He didn't clearly, even though the Obama administration does not use the language of the unitary executive theory, you won't, at least as far as we know, there's some memos that are secret and still classified, but as far as we know, there are not memos that say what John Yoo said. The president can set aside the law. What they do in a way is a little more, it's a little more devious. The Obama administration takes positions where they say, we're following what Congress wants and we're obeying the Constitution, but we're going to reach a conclusion the president can do what he wants. So it amounts to the same thing. And I think it's troubling. I'll talk about one example of this. There are a number I talk about in the book. One example of this is the kill or capture program. The drone program you hear about, there are kind of two aspects to it. One is drone strikes in Pakistan, places like this, where there are insurgents or people believed to be insurgents, where drone missile strikes take place. And sometimes the criteria that are used are pretty troubling. If you're a male between certain ages, can be classified as a militant. So these drone strikes go on. Many civilians are killed, including children. There are horrible stories about this. And that's one aspect of the drone program. The other piece, I don't talk about that. Those raise very important issues, but mainly issues of international law. And I'm mostly talking about the U.S. Constitution. The other aspect of the drone program, which I do talk about, is how it's been used with U.S. citizens at 1 to 3. It's unclear because the Obama administration has not precisely explained this. But what I mean by this is the kill or capture list. There's Anwar al-Awlaki. Have people heard of this man? People know who he is? Anwar al-Awlaki was a U.S. citizen. He's born almost, I think, 2 days after me in 1971, almost the same birthday. So not that I don't want to associate myself with him. Just like Abu Zubaydah, he's not a sympathetic figure. And that's the hard thing about this. It's, you talk with these people and you feel like you have to be defensive. The point isn't whether he's sympathetic. The point is, will the United States apply the rule of law? And I think with al-Awlaki, just like with Abu Zubaydah, the answer is no, it didn't happen. So al-Awlaki is this guy who's born, I think, in New Mexico, went to graduate school. I think he got a master's degree at a university in the D.C. area. Was pretty immersed in American life. But after September 11th, he moved to Yemen and became associated with this group called Al-Qaeda in the Arabian Peninsula, which is a greater threat to the United States today than the original Al-Qaeda. There are all these offshoots. Al-Qaeda in the Arabian Peninsula is one, Al-Qaeda in Iraq, Al-Qaeda in the Islamic Maghreb in North Africa. And Al-Qaeda in the Arabian Peninsula has been behind some really scary things. They planned this fortunately unsuccessful 2009 Christmas Day bombing. They planned several other attacks in the United States. They've been they have a base of operations in Yemen, a country that's ungoverned outside of the capital area. So they're certainly a threat. And al-Awlaki himself was clearly associated with this group, just like Abu Zubaydah was clearly associated with the original Al-Qaeda. But it's not clear exactly what his role was. What is clear is he was at least a propagandist. Because he spoke English, he was very valuable to the group. He could give sermons. He was a religious leader too. He gives sermons that would go on the internet and talk about. He would praise the September 11th attacks and say this was a good thing and more attacks like this should be taken. He exchanged emails with Major Hassan, the man who was behind the shootings at Fort Hood, talking about whether suicide bombings, other killings could be justified in religious terms. So al-Awlaki is certainly no innocent, just like Abu Zubaydah was not. What happened with him, I think, is still troubling. What the Obama administration said was, and this again was done secretly, it wasn't known about initially, they developed this killer capture list. People who were so dangerous, they posed an imminent threat, though imminent threat isn't what you'd think it would be. It's not. It doesn't mean he was about to attack the United States. The way they define imminent threat is at any given time he might be planning attacks that could be taking place, but it's not that he's actually about to attack the United States. If there's somebody in that category who's so dangerous that they have to be targeted, the Obama administration gave authority to the military to capture them, or if capture was not feasible, to kill them. Most of the people on this list were not U.S. citizens. Al-Awlaki was. And the problem there, the Constitution actually protects non-citizens as well. But there's this tradition in U.S. law that citizens get more protections than non-citizens, which I think is problematic in and of itself. I think they're bad. There's kind of problems with that too, which I won't get into. But at the least, the Supreme Court has made clear that U.S. citizens get protections under the Constitution. There was a case in 2004, a U.S. citizen, a man named Yasser Hamdi, who it seems like was probably in this innocent category. He was captured, I think he was 21 years old, captured in Afghanistan, accused of being a member of the Taliban, taken initially to Guantanamo. When it was learned he was a U.S. citizen, he was transferred to a military prison in Norfolk, I think in Charleston as well. Supreme Court decided his case ultimately, and they said you cannot hold this guy without any hearing. He's a U.S. citizen. Fifth Amendment of the Constitution says you can't deprive any person, actually, but the court emphasized citizen. You can't deprive him of liberty without due process of law. So you've got to give him at least a limited hearing. Based on that precedent, al-Awlaki's father, when he learned that his son was on this list, said, wait a second, you can't kill my son. You are arguing that he's planning attacks. You haven't proven that. And the U.S. government conceded that. But the government said, we don't have to provide any hearing. We can provide due process within the judicial branch. Eric Holder gave a speech to Northwestern Law School, I think in 2012, after this all became public. And he said, we know about the Hamdi decision. We have to give due process. We're not rejecting Hamdi. And this is where I'd say the Obama administration gets a bit kind of crafty about this. We're not rejecting Hamdi. We just think due process does not necessarily mean judicial process, which to a lawyer or probably anyone who reads the Constitution is a bizarre statement. The whole point, the Hamdi case says, the whole point of due process, of separation of powers, is to prevent the president from having too much power. The killer capture program, where the executive branch provides due process on its own, really flies in the face of that. So the idea the Obama administration said is, we can kill this guy. Due process is not a concern. We'll provide it within the executive branch. The other problem was it wasn't even clear that Congress had authorized this. After the September 11th attacks, Congress passed the authorization for the use of military force, which said basically you can go after al-Qaeda or anyone who's harboring them, which meant the Taliban. But it didn't go any further than that, not expressly anyways. Again, as I mentioned, al-Awlaki was part of al-Qaeda in the Arabian Peninsula. They didn't exist in September 11, 2001. Now, that might be a technicality. The Obama administration thinks that they can claim, and some lower federal courts have agreed, that al-Qaeda in the Arabian Peninsula is a co-belligerent with al-Qaeda. And there is some legal precedent for that. What bothers me about that, though, as I said, given the precedent of the Bush administration, I think it was essential for the Obama administration to follow through on what Obama said as a campaigner. This will be a break with the Bush administration. We're going to restore the rule of law. We're not going to play games with this anymore. Instead, they said, we think Congress has implicitly given us this authority, and we don't think there's a due process problem because the judicial branch is providing it on its own. So al-Awlaki's father brings a lawsuit. District of Columbia gets dismissed because the district court judge says if your son wants due process, he can turn himself in, which it's probably problematic too, given most people who are turned in and go to Guantanamo and never get a hearing. But al-Awlaki himself is killed in September 2011. A couple weeks later, Anwar al-Awlaki's son is killed. This is where the story even gets more troubling, I think. When the son was killed, the reports initially were al-Awlaki's son is killed. He's a 21-year-old militant. Turned out, no, he's 16 years old. He was 16 when he was killed, and no known associations with terrorist groups. He was associated with his father, who clearly was associated with a terrorist group, but he wasn't. So that's and the Obama administration, I think, this is kind of an odd piece of it. I think they understand what they're doing is dangerous. In the 2012 campaign, there was a story in the New York Times that the Obama administration, obviously they didn't know who would win, and they said, if Romney wins, we don't want Romney to use this program as precedent. And they were trying to scramble around to prevent that, which to me seemed insane. The whole point is your Presidents Bush and Obama have basically done what they have wanted. Why wouldn't Romney do the same thing, no matter what you do now? And I think the fact that they acknowledged that and were trying to scramble to prevent this was very revealing. Basically what it meant to me is, what they're saying is they think Obama can be trusted to do this, but not other people. And that's a bad way, I think, to develop precedent for presidential power. So let me very briefly read a last quote, and then I'll take questions. During World War II, I mentioned how presidents turned to precedent. And there were some similar things that happened. For instance, during the Roosevelt years, military trials were used for some captured saboteurs. There was this bizarre episode early in World War II, happened again later as well, actually, where 2 teams of Nazi saboteurs landed on the coast of the United States. They successfully landed. Submarines were very active off the east coast of the United States. One group landed in Long Island, one group landed in Florida. They had all lived in the United States at one point and spoke English. One was a U.S. citizen. And their task was to gather intelligence, blow up U.S. installations. They had been trained in explosives. They had money with them. But something went wrong. It's not clear exactly what. Most likely, they didn't really want to do this. They'd been pressured into it. And when they landed, the leader turned the rest of them in. And Roosevelt put them on trial before a military tribunal. There were really big problems with the way the trial worked. Justice Scalia referred to this as the Supreme Court ultimately signed off in the process. Justice Scalia said, not the court's finest hour. I think he's right. What they were assigned military lawyers on. One of them, a man named Kenneth Royal, said something I think is relevant today as well. He said he was a member of the U.S. military. He's a military lawyer. He obviously wanted the United States to win the war, but he said, I don't want us to win it by throwing away everything we are fighting for. Because if we do, we will have a mighty empty victory if we destroy the genuineness and truth of democratic government and fair administration of the law. One thing I remember, I'm sure you heard this too, in the days after September 11th, people always talked about don't let the terrorists win. And this kind of slogan. There are a lot of things you can't prevent, unfortunately, terrorists from doing. I mean, there will be attacks, there will be attempted attacks. That's a reality. What the United States does have control over is our system. And do we continue or I guess restore a constitutional democracy with the rule of law? That's something we can control, and I'm concerned that it's questionable what will happen, especially, I mean, I don't want this to happen for any reason, but especially if there's another crisis. So I'm glad to take questions about anything. It can be, the NSA program's got in the news recently, anything at all. I think if you can go up to the microphone, yeah, is it up here? I think that's probably best. Oh, there. If people want to go up to the microphones. Oh, you have a question in the back. Do you mind coming up to the microphone? Thanks.
In the unitary theory, can the president, I guess you've covered this in your last thing, order somebody's death because he's the president?
Sure. Yeah, I think logically, yes. Nixon was asked about this,
could
actually.
Could he open a phone book to a state, put his hand on somebody's name and say, I want this person killed?
I don't see why not. The logic of the unitary executive theory is the president has, because the Constitution gives the executive power to the president. And the language is slightly different than the language in Article 1 that gives Congress its power.
Yeah, I'm a lawyer.
So you know about this. Yeah, just for other people.
Yeah.
So the logic is the president has the executive power, has all the executive power, and if Congress tries to infringe it in any way, or state legislatures by passing laws against murder, the president can set them aside. And I think logically that would mean, yes, the president could order murders. Absolutely correct. And it's Nixon was asked about this, and some of the precedent for the unitary executive theory is what Nixon did. Nixon's theory, obviously, it was a different context. Nixon was doing this with political opponents, not suspected terrorists. But Nixon was asked about this in the Frost-Nixon interviews.
Has the Obama administration made any comment about the unitary theory?
They rejected.
Whether they called it that or something.
They rejected. There's a lawyer who was served in the Obama administration who was very critical of the unitary. Harold Coe himself was one of the biggest critics of the unitary executive theory. They repudiated. There's a man named Marty Lederman's a professor at Georgetown Law School, I think Georgetown Law School. He was in the Office of Legal Counsel under Obama. He wrote the underlying memo, which is still secret, which justified the al-Awlaki killing. And he says, yeah, we reject it. He says we're taking a different path. What I would argue is, I think it leads to the same result. It leads to the result that the president can do what he wants.
If it wasn't the unitary theory, what was the different path?
The different path is that they claim to be following statute in the Constitution, but what I've seen when I look at it is they always find a way to get around it. And so I would argue it doesn't really make a difference. It's more kind of window dressing, if that makes sense. Yeah. Anyone else have a question?
Can you finish that Nixon story that you were...
Right. So Nixon in 1977 did these interviews of the basis for a movie, which apparently, I haven't seen it, but not completely historically accurate. But the interviews are accurate, and they're around. Though it's hard to see the complete interviews. I found there's like an hour or so that's available, and then there's kind of pieces on the internet. Nixon in 1977, after he had resigned, was asked basically this question this man was just asking: could you order a killing? And Nixon's answer basically was, I don't know a president who would do that. But the logic is, Nixon said in those interviews, Nixon was also asked, how did you justify your actions? Wasn't this illegal? And Nixon said, when the president orders something, it means it's not illegal. So, it logically, yes, I think it justifies anything. It's a theory, and I feel weird saying this because it sounds kind of alarmist, but it's essentially a theory, at least in a certain area of either monarchical power or dictatorship, whatever you want to call it. But it's certainly something the framers would have rejected, and I think most Americans hopefully would reject.
When
Oh, I'm sorry. Yeah, please go ahead.
when Wilson's Attorney General executed mass deportations after
Oh, yeah,
World War I,
Palmer, yeah.
how does that fit in? I mean, was that at the time? Was there any sense that they went too far?
Yes,
or did
there
that
was.
set a precedent that?
A very brave Undersecretary of Labor actually was instrumental in stopping this, and the federal courts stopped it. There was a man named Mitchell Palmer who was Attorney General under Wilson and was once considered a likely presidential nominee. And he was about the Palmer raids in 1919 and 1920. He's the man behind this. He ordered that people were suspected of, at the time there was a big fear of anarchy, and it was just after the Russian Revolution. People were suspected of basically being dangerous leftists, would be rounded up and deported if they were not citizens. The Palmer raids have become infamous, and even at the time there was opposition. I don't know exactly how it got involved, but there's an Undersecretary of Labor who said this is not okay. This is the executive branch acting in contravention of law. And there were cases brought in federal district courts, and federal district courts, to their credit, said you cannot do this. You can't simply circumvent the legal process. So people did stand up to that. That's I include that in the book. There are some good examples. There are some times when people stopped it, and that's one. And Mitchell Palmer himself was stopped. He predicted. He said there will be a revolution in the United States on, I think, May Day. I think he said 1920. He was confident this would happen. And there was a real fear at the time, and it looked like he would kind of ride to power in this. He did not, and partly it was because of this reaction to the Palmer raid. So that's a good episode. Thanks for asking about that. Oh yeah,
Hi. Practically speaking, how could we hold the executive responsible?
Right.
I mean, either in person or in property, because the whole system now seems so questionable as to how it's operating, and there almost is no responsibility from this upper layer of government to hold them. How do we do it? I mean, can we put them in prison? And I'm talking theoretically.
Yeah,
because
no. It's an essential question to ask. I'm sorry, I didn't mean to cut you off. Go ahead.
Yeah, no, that's right. And or their wealth or anything. I mean, they just seem to be above the law.
Well, let me suggest some maybe less dramatic measures. I don't necessarily. I don't know. Maybe there are other ones too. You're right. It's an essential question. It's one that always comes up in class when I teach this. People say, "Well, what can you do?" I think this is just my own view. People have different views. I think there are ways to do something. One, the man who wrote the foreword to the book, a man named Lou Fisher, is a prominent scholar, separation of powers, worked at the Congressional Research Service for 35 years. His idea is basically that Congress needs to reassert itself. And I think, people obviously, now the problem though is how does that happen? I have no idea. I always ask him that. I'm like, well, what do you do? But I think in theory that would be great. I mean, the framers of the Constitution created a system where there's supposed to be checks and balances, and the Congress and the courts could assert themselves. The courts now, again, just as the question about the Palmer raids points us out, the courts have not been completely asleep on this. There have been 4 major cases since September 11th involving presidential power, and every single one, the court, including in the Hamdi case, was an 8-1 decision. Everyone except Thomas said the president has gone too far. Now, the problem, though, is did that have any effect? I'm not sure. So the short answer to what you're asking is I would say Congress needs to assert itself. The courts need to assert themselves. People need to demand answers. The press needs to do a much better job. Now, I know none of these are probably satisfying, but that's the best. Or like on a personal level, here's how I feel. Because sometimes you feel like, what can you do? I mean, these people are so powerful. On a personal level, people probably have their own different ways to respond. I like to write, so I like to write about it and kind of raise these issues and hope that people will get energized about it. But I realize all of those are almost certainly not satisfying answers. That's the best I can do.
So there's no way to put something at risk, be it their perpetual income that they get after.
Sure. I mean, if a president is impeached and removed from office, then you can pursue criminal remedies. I mean, I don't think that's likely to happen. Some proponents of broad presidential power say that this was a really stunning book to me to read. There are 2 law professors. One's the son of a very famous federal judge. The son is Eric Posner. He's a professor, I think, at the University of Chicago. And then his co-author is a professor named Adrian Vermeil at Harvard Law School. And their conclusion is presidential power is a good thing. We shouldn't worry about it. We should want a president doing these things. And the only checks on presidential power are basically impeachment and elections. So some proponents of broad presidential power would say, if you don't like it, take him out of office. Now, that's not a very useful remedy. That's not really going to happen. So from a kind of pragmatic perspective, that's why I think about these other things. But in theory, I mean, sure. I mean, there are mechanisms in the Constitution for taking action when these things happen, and or especially the president during office cannot be prosecuted unless he or someday she is removed from office. But people like John Yoo, I mean, I think Obama made a mistake there. His argument was we have to look forward, not backwards. But I know it's difficult. I understand this. It's not fun to want to prosecute these people, but torture was done. It was justified. I agree that some action has to be taken. I'm sorry I can't say anything more kind of satisfying than that. But it's an essential question. Oh, Kimberly.
Well, I think my question is very similar to that one. But given the severity of the threat we face, could you talk specifically about, I mean, for example, is kill and capture wrong in premise?
Good point.
You said kind of in abstract, will Congress or the judiciary have to reassert themselves?
Right.
I mean, specifically, what are the
Excellent
things,
question.
what are the specific
I don't think kill or
policies
capture is wrong
actions
in
that need to
practice.
change?
No. So John Yoo, when he talks about this, he says, kill or capture, we killed Admiral Yamamoto during World War II behind enemy lines. He wasn't on the battlefield. That's true. Admiral Yamamoto was the admiral who planned the Pearl Harbor attacks. And the U.S. military, in an incredibly well orchestrated and daring mission, was able to, they figured out that he was flying around to inspect Japanese bases way behind enemy lines. And U.S. planes attacked his plane, shot him down, and killed him. Obviously, he didn't get a trial. And John Yoo's argument was, we didn't give him a trial. Why should we give al-Awlaki a trial? The problem is we're not in the same situation. If yes, Admiral Yamamoto, there was no question. He was, or sometimes people will say, wait, we killed U.S. citizens on the battlefield in the Civil War. Confederate soldiers were U.S. citizens. That's true. The problem is, in those circumstances, we knew for sure who those people were. There was no dispute. So I'd say to Kimberly's point, like for instance, good example, I guess, is bin Laden. I don't think there was anything problematic under U.S. law about killing bin Laden. It may be under international law. There's a question about whether Pakistan consented to this. That's an important problem. But under U.S. law, killing bin Laden, there's no problem. Congress clearly had authorized that. He clearly was somebody who was engaged in conflict against the United States. So I guess the question I would ask is, if you're going to put someone on this list, do you know with certainty who they are? And if you do, then sure, I don't think that's problematic. There might be policy problems, but not legally.
But does the nature of the threat today, or the idea of non-state actors, or an unending global war on terror, I mean, does that change then? I mean, I think your point was, for example, that we were at war with Japan, so it sort of all things were acceptable in those terms. Is it different now because we're in a different kind of war?
It is, and I don't mean to be too dismissive of that. I mean, al-Awlaki, again, he was not a nice person. He was somebody who certainly there were dangerous things about. And so what exactly did you do about him? I'm not sure. I guess as a lawyer, my first point would be, though, bring it within the law. At the very least, engage other branches of government. Like, here's a kind of, probably overly simplistic solution I would offer. If al-Awlaki is as dangerous as the government's saying he was, and if they have information they can't share publicly, Congress has procedures set up to look at information in secret. The courts do as well. Provide this information secretly and make your case. And if, at the very least, my concern when the president acts alone is that the framers of the Constitution said when power is concentrated in one branch of government, that's the definition of tyranny. So I get concerned about that. Get other branches involved at least. And if it turns out that this is someone who needs to be targeted, you're right. I don't mean to go too far in the other direction and lose sight of the fact, yes, there are real threats and there need to be real responses. I just would like to see that they're done in a legal framework that doesn't give the president kind of concentrated power. Okay. But your point, yes, absolutely.
And so legality is in separation of powers. It's okay. So
I'm sorry. Would you?
Well, so the idea that the president can do anything the president wants to do it's not in what he does. It's that he does not consult that makes that action illegal. Okay.
I think it's right. So Harold Koh, the man I mentioned before, he had a reputation as being a critic of presidential power. He wrote a book called The National Security Constitution right after Iran-Contra, where he said the problem with presidential power is presidents act alone. What they should be doing is consulting, cooperating with Congress. I agree. There's a famous I think Justice Frankfurter said this: the Constitution is not a suicide pact. And it's sort of like it's cutesy a little bit, but I mean the point is, of course, the framers of the Constitution wanted. You always hear about they wanted to limit government power. Of course, that's true, but they also knew from their own history that it was also dangerous if government did not have enough power, and they wanted to make sure government could act. Right. They even talked about Congress has the power to declare war, but when they drafted that part of the Constitution, they changed the language, and when they did, They said, we want the president to be able to respond to repel a sudden attack. They wanted to make sure presidents could act in real emergencies. But I think the normal position, so when there's a real emergency, I talk about in the book, the president can and should act. On September 11th itself, planes are flying around. Vice President Cheney is in the bunker. President Bush is at an undisclosed location. They're trying to figure out, do we shoot down other planes if they're going to fly into buildings? I think, yes, that's the kind of action a president could take in a real emergency. The problem to me comes up is, if the emergency goes on forever, does that mean presidents keep having this power? And I would say no. But your questions are good ones, and thanks for reminding me that. Sometimes I go too much in this direction of being critical, and this is a good point to highlight. Thank you. Oh, yes.
Okay. Going back to times of Jackson, he practiced genocide on American Indians, was part of Manifest Destiny. He imprisoned them in reservations, and he actually wasn't contested by anyone. And this went on for some time. Going to Lincoln, he got rid of habeas corpus during a civil war. So there are times when presidents take their executive powers and abrogate normal courses of action in a disastrous mode. So you have to go really back to various presidents. Sometimes predecessors are beneficial. We could have gone to war with France, but Adams said, no, we're not going to war.
Well, we did go to, there was sort of a half war. And that's it. So wait, I didn't mean to cut you off, though. There's a couple of points I wanted to make, but go ahead. Please
but
finish.
They stopped.
What's that?
They were imprisoning American sailors at the same time.
Yes.
Adams said, we're not going to go to war. So there are times when presidents take actions without challenge. Now, what happens when this takes place historically? How do we look at it today?
Excellent point. And so I think the first thing is understanding exactly what happened. So the Lincoln example you gave is a famous one cited by advocates of broad presidential power. Lincoln did unilaterally suspend habeas corpus. That he ordered, for very good reasons in his defense. It doesn't necessarily mean it was constitutional, but the reason he did this was because Washington was basically in danger of being cut off from the rest of the country. Virginia had seceded. Maryland was a slave state. The legislature was debating secession. It looked like they might secede in the summer of 1861. Lincoln told the commanding general of the Union Army, a man named Winfield Scott, you can take people into custody who are dangerous and hold them without providing them access to court, suspending habeas corpus. This was challenged in court. The Chief Justice of the Supreme Court said, Lincoln cannot do this. The president does not have this authority. Only Congress does. So the court tried to stop him. Lincoln essentially ignored that order. He didn't follow it. But what he did do, and this I think is important, he went to Congress on July 4th, 1861, or actually he sent them a written message on July 4th, 1861, and he said, I did things that may not have been strictly legal, but I did them under an emergency, trusting that the people would ratify it later. And now I'm coming to you, Congress, and asking you to sign off on it. Basically, Kimberly's point. Can the president act in an emergency? And Congress said, okay. Now, I think that's a plausible model for dealing with emergency. The president acts initially, as you said, in contravention of the Constitution, but brings it within a legal framework by turning to Congress for power. Same thing with Adams. Now, the Adams example suggests other problems. So in 1798, there's Britain and France are at war. There's the Napoleonic Wars in France. And there's a question, will the United States enter into it? Washington was trying to keep the United States out. He gives a speech when he leaves office about avoiding entangling alliances, not getting involved in Europe's problems. Adams develops this kind of anti-French attitude. His vice president is Jefferson. Jefferson's sympathetic to the French. And French ships, as you said, were stopping American ships, raiding them, taking U.S. sailors, impressing them into the French Navy. And there's a question about what to do about this. Adams could have acted unilaterally. You're right. He did not. He went to Congress, and Congress authorized what Adams referred to as the half war against France, a defensive war to respond to these attacks, to authorize ships to defend themselves against attacks. So he did get congressional authorization. Now, that part of I think is okay. The part that becomes problematic is he also asked Congress, give me tools to respond to these enemies at home, the Democratic Republicans who are sympathetic to France. That's where you get the infamous Alien and Sedition Acts from, which I think pretty plainly were unconstitutional. But Congress enacted them, and they went into force, and they weren't challenged in court. They went away because they expired. One piece of them actually survives today. So the point I would make there is you're right. There are examples of this. I guess the 2 points I would make is, one, sometimes the presidents might have been wrong. Another is sometimes they might have done something that seemed to be outside the constitutional framework, but it can be brought into it. A final point is sometimes they acted with Congress, like Adams did, or like Roosevelt did with the internment of Japanese Americans, but it still wasn't okay. Even when the president acts with Congress, the Constitution still applies. I mean, Congress can't say, yes, you, the president, can do whatever you want. That still would be unconstitutional. But yes, your points are good ones.
What happens when the president is incapacitated like Wilson, and his wife was really making decisions.
Well, that's a problem. I don't think the Constitution, even at the time, provided for a president's spouse to take power. So yeah, that's of course a problem, and you can't have that happen. That's a different kind of problem. That's just a problem of, I guess, people within the executive branch, assuming they understood this, recognizing it was a problem and doing something about it, and that's a different sort of problem. That's happened in the court as well. There was a very prominent Justice William Douglas, and I think a very rightly renowned justice in a lot of ways. Justice Douglas, toward the end of his life, was having problems and was mentally incapacitated, but continued to serve on the court. And what the other justices did was they said, if there's a 5-4 decision, we won't let his vote be the deciding vote. Now, is that the right way to resolve it? I don't know. But I think those kind of things, it depends on the people who know what's going on to do something about it. Because other, people, the public may not know. And that's an important point. That depends on people who have knowledge doing something about it. Oh, yeah.
So you mentioned that during the election, the Obama administration attempted to preemptively restrict Romney's ability to execute the precedent that Obama had set. Is there a way that they could have feasibly done that? And can you preemptively restrict a president's power coming into office? Again,
to the question before, the logic of the unitary executive theory is no. I mean, it does. Under the unitary executive theory, precedent doesn't really matter. Law doesn't really matter. It's kind of sort of a quaint notion in a way that the Obama administration is saying, well, we'll stop the next precedent because we'll say this isn't okay. There's two problems. First of all, a future president might just say, why should I care about this? They might fully embrace the unitary executive theory. They might find ways around it, as Obama has done. So I don't, it's, and also probably most centrally to me, what it shows is there's the Supreme Court in a decision just after the Civil War said, we can, and I think Justice Jackson said this as well in an opinion in 1952, the Youngstown Sheet case, which is an important case for presidential power, said we shouldn't confuse the occupant of the office with the office itself. And I think that's what the Obama administration was doing. They basically were saying, trust us. We can be trusted to do this, but don't trust the next person. The Supreme Court in 1866 said not everyone who sits in office is going to be a Lincoln or a Washington. We should make rules for all the presidents. So that's the problem I think with it. But apart from that, I don't know how it would restrict a future president, because of a president who's really embracing the unitary executive theory would say, I don't care. I'm the president now. They got it wrong. I think it infringes on executive power. I'll set it aside. So it's troubling, to say the least. It was a weird story to see. Hi, Eleanor.
Hi, Chris. Can't wait to read the book.
I appreciate it.
Very exciting.
Thank you.
I was just curious if any former president has ever, after they've left office, admitted they did something wrong or said something prophetic for the future of how this abuse is so easy to fall into.
That's an interesting question. Presidents, it's hard to think. Executive branch officials, yes. Mm-hmm. There are certainly people there were some people in the Bush administration, even at the time, and this was something I was interested to find when I was writing the book, who at the time, and this gets to the point you're asking about, what do you do like if a president's incapacitated? There's a man named Jack Goldsmith, who was a lawyer in the Office of Legal Counsel. And he was a staunch Republican. He co-authored articles with John Yoo, who I wrote about. They were friends. They played squash together, apparently, and they were very similar politically. Jack Goldsmith, when he found out about the unitary executive theory, said, "This is wrong. This is unconstitutional. It violates the rule of law, and we can't keep doing this." He was asked. This is the Ashcroft Hospital visit I was mentioning before. Goldsmith, this was the warrantless surveillance program. Goldsmith said it can't go on. It can't continue. And he forced the Bush administration to change its course. Now, I don't think what he did was perfect. One problem I have with what he did, it's easy for me to say this, I guess, is he didn't make it public. This all was going on in the spring of 2004, and there were a number of, including Ashcroft himself, prominent government lawyers were prepared to resign over this program. Nobody found that out until late 2005. That, I think, would have been useful information before the election. But so he's one, he's one who did recognize this. There are other people, other executive branch officials in the Reagan administration, a man named Bruce Fine, Colin Powell's advisor Lawrence Wilkinson, who have been critical of presidential power. John Dean, probably most notably, he was somebody who went to prison over Watergate, now has become very critical of presidential power. But presidents themselves, what's that? Oh, really? Oh, that's interesting. All right, I didn't know about that. Well, that's the one. That's the only example I can think of. Then other presidents, I mean, not that I can think of. It's a good question. So, I would tend to think I don't really look to the president themselves to take action. The Jen Sermon says before, I say, like, I think of presidents like great white sharks. Like, they do what they do. If you put a seal in the water with great white sharks, they will attack them. It's not the shark's fault. Or if you're a surfer and you put on gear that makes you look like a seal, they might take a bite of you. That's not really their fault. Presidents will do this. And the point to me is, do you have other people there who will recognize when there's a problem? So I wouldn't, your question is a smart one. I should look at that more because I don't really know. And you're mentioning about Truman. I'd be interested to look at that more. But my instinct would be, are there other people who, even when something's done secretly, someone knows about it. People knew about Watergate. People knew about this warrantless surveillance program. There are people other than the president who can take action and sometimes do. So that's sort of what I would hope for. But I'll think about them more. It's a smart question. Nice.
Chris, we've got time for one.
Oh, okay. Oh, please go.
This is following up on that question. I wonder if you have considered, or maybe we would like to consider for a future research project, some of the ways that the internal structure of the executive branch can be used for exactly this reason. That it is people inside the executive branch sometimes who are most effective at slowing down the march to a particular conclusion by the president. And your example of Watergate is one of them. I mean, one of the things that was most effective in the whole Watergate scandal was the not mass resignation, but the resignation of some of the key members of the Justice Department.
Yeah, right.
One of the things that tends to keep the FBI somewhat apolitical is the fact that the director of the FBI has a fixed term, and is by tradition does not tender his resignation at the end of one administration, so that a new one can be appointed. And it may be that some of those kind of techniques, to the extent that they're not ultimately found to be unconstitutional, the way that one of the attempts at balanced budget structure using the comptroller was, they might be a way for the executive branch to, in a sense, police itself by setting some of its own powers outside of its executive authority.
Yes, I think I am going to look at that in my next book. Jack Goldsmith's conclusion, he was a lawyer in the executive branch, so he basically says that is a good idea and it does work. What I would question is, does it really work? And I'm going to look at that because I'm not sure. I think Goldsmith did some good things, and the current FBI director, actually, Jim Comey, was an ally of Goldsmith's. So I'm kind of hopeful that he'll be someone who will have a good approach. But I'm skeptical as to whether it's perfect. Like, I wouldn't count on that by itself. That's sort of this, like when Eric Holder says you can have due process within, it doesn't have to be judicial process, it can be within the executive branch itself. I get skeptical about having it just within that group. But does that not mean that executive branch officials can set limits? No, I think absolutely that's an important check. I would be careful not to say it's the only check. But yes, if for my next book, that's something I do want to look at and will. So I appreciate the question.
I look forward to that.
Thank you, everyone, for all the questions. I really appreciate it. Thanks for coming. Thank you.